It's going to be actually a fairly interesting topic, given that there's been some developments in the law that we're going to speak about that are greatly creating risks in this area. One decision of great importance by the full bench of the Fair Work Commission. So we'll get to that today. But today's topic, we're going to talk about outsourcing in 2025 and knowing the legal boundaries before you hire. And particularly, we're going to talk about a little bit the impacts or the risks of engaging overseas contractors or overseas employees, as some of them were found by the full bench of the Fair Work Commission. What I'm going to do, though, we're going to set the agenda. So I'll start with the general background about the legal risks associated with engaging overseas independent contractors, and then we're going to talk about the general approach to differentiating the contractors from an employees, the risk of sham contracting, and then I'm going to go through the specifics of two cases. At first instance, before one commissioner, and then also the approach taken by the full bench too. And then generally we'll speak about what steps can be taken, obviously, to mitigate the risks as a result of these decisions. Sorry, I'm just getting my slides in order. So what are the legal risks associated with engaging independent contractors? Well, the first one can occur, which is the misclassification of the worker type. And it's quite important here is that what happens when we have a contractor's agreement, but we treat them like an employee or vice versa. And the risks are that there can be tax implications, meaning that we haven't withheld their PAYG tax appropriately. We can have a situation where we deem them to be a contractor in an agreement, but the rest of the agreement makes them look like an employee, and that means that we're liable for paying them superannuation. And more importantly, what we're seeing now is that there's also Fair Work compliance issues. So quite often we all think that an independent contractor is excluded from being able to bring things such as claims for unfair dismissal or seeking their entitlements under the National Employment Standards, such as redundancy payments or workers' compensation payments, etc. That has become particularly relevant given that what we're going to speak about today is that if we misclassify or we draft the agreement in such a manner that it's not clear that they're an independent contractor, all these other issues will now come quite strongly into play. The other situation occurs quite often is where we engage an independent contractor, but we don't bother to put it in writing, so we don't get a written agreement. And we end up having a situation where we're receiving invoices from a party, and it seems to reflect, invoices seem to reflect an independent contracting arrangement, but the nature of the agreement exposes us to the exact same risks of misclassification, in a sense that they say, well, the nature of my work was that of an employee, not of that of an independent contractor. And I want my entitlements. I want my holiday pay. I want my notice of termination, or I want my redundancy pay. All things that the employer hasn't budgeted. It also means that we're at risk of them saying I've been underpaid. I issued these invoices. Apparently, the contractor says I paid GST, and as a result of that, I'm falling below my modern award entitlements, and you've underpaid me for an extended period. Another risk that sort of occurs when we draft an independent contractors agreement is that quite often how we direct the work to be performed can be viewed as being basically over control of work. Courts can view that if we're overly stringent in how we direct the work to be performed, is that we're actually requiring that contractor to work like an employee. So if we have conditions quite firmly in our independent contractor arrangements that say how, so the manner of the work, when, particularly in relation to, say, an overseas employee, is that you must be available in Australian business hours, and where and on what. So it could be like you need to perform it at a particular office, or what you need to perform it on these particular systems at these particular times, and that you can't delegate the work to anybody else. That can be viewed as being far more indicative of an employment relationship than an independent contracting agreement. The other aspect too is where we completely just overlook other legal and tax obligations. So there are different tests. Certainly the test of who's a contractor and who's an employee for the Fair Work Act is specified, and we've all been sort of familiar with all the changes that have been brought in with the High Court's Rosado decisions and then the amendments to the definition of employment. But there are other tests too that need to be considered when we draft an independent contracting agreement. And they include ATO guidelines, and on top of that, particularly with respect to superannuation, and PAYG, GST registration, etc. So if we draft it in such a manner where the nature of the work or the obligations of the work may well qualify for the Fair Work Act, but we're not considering what happens with respect to superannuation or workers' compensation for that matter, those tests are slightly different compared to the tests that are in the Fair Work Act. And if we're not considering those while we draft those agreements, we can find ourselves in breach of those legislation. And again, a hefty requirement for back pay or hefty penalties can be imposed, not by the Fair Work Commission, but by the Taxation Office, or we are found to have undeclared wages for workers' compensation purposes, and quite a large penalty can be imposed at that stage. The final thing, and I think this is one that I will be quite topical today, is that we tend to assume that overseas workers are excluded from Australian rules. And I think this is a massive change. If I engage someone in the Philippines, most employers would tend to think, well, Australian law wouldn't apply. But you'll find out today that that's not necessarily the case. And it's a fairly dramatic change, is that the first decision of Pesqueira came out in September last year, and it went on appeal and was determined, I'll just pull up the date, very early this year, but it was determined by the full bench on the 21st of February 2025. And at both instances, a person who was working in the Philippines was deemed to actually be an employee under the Fair Work Act for the purposes of the Fair Work Act, and was able to bring an unfair dismissal claim against their employer. So even though they had a written contract that said that they were an independent contractor, the Fair Work Commission, and the full bench approved of this approach, examined the nature of that contract and deemed, well, it wasn't really a true independent contracting arrangement. And as a result, the employee was now able to continue on bringing an unfair dismissal claim against their former employer as it had been determined, which is quite a dramatic change, because all the work that this lady was performing was based in the Philippines, and I'll go through how they arrived at that conclusion. The other aspect is that quite often we're running on poor, outdated contractor agreements. So if I'm talking to somebody here and you're saying, well, I got my independent contractor arrangements reviewed 3-4 years ago, there's been dramatic changes in that time in this space. And it's an ever-evolving space. And as more and more requirements come through, it's becoming a little bit more clear what they're actually looking for and what are the requirements that should be based in that independent contracting arrangement for it to stand up if it's ever placed under scrutiny. Now, if you're running off an old agreement and yes, it's been working fine, that's not really an indicator that it's a safe agreement, because these sorts of disputes only tend to arise after the arrangement has come to a conclusion. People are quite happy to work under agreements whilst things are moving smoothly, but say the work dries up or the work goes elsewhere, or there's a dispute as to the nature of the services that were performed and the agreement comes to an end, that's when these issues rear their ugly head. So the issue there would be to perhaps have a look at what are your current arrangements and see if you think they actually will stand up to scrutiny if this relationship broke down and further action was taken by the disgruntled party. And I think that's probably one of the key points I want to make today, is that there has been a lot of change in this area, and that strengthening it now is the time to do it. You can't really retrospectively go back whilst you're in the middle of a dispute and ask a ask the contractor to update their agreements. It just won't happen, and you can't really rectify the deficiencies at that time, but you may well be able to update your agreements as we currently stand. So I'm going to talk about the key ways that the courts and the commissions look at an independent contracting arrangement to determine whether it's a true contracting arrangement or whether it's one of employment. Now, the key here is that the High Court came through on the Rosado decision and personnel contracting decision, and the common law, as it currently stands, says contract is king, and we look at the terms of the written agreement at the time it was entered into. Now, that's been slightly modified by the Fair Work Act. It says that we look at the nature of the employment moving forward, and on top of that, they also say where the agreement no longer reflects that arrangement, we actually look at the operation or how the agreement has been put in place. But in many regards, what's happened is that that amendment has been brought in to sort of water down a little bit of the impact of the position of the High Court that contract is king. But they, at both stages, the Fair Work Commission and also the courts will place a lot of emphasis over what are the actual terms contained in your independent contractors agreement, and does it really reflect a true independent contracting arrangement? And the Fair Work Commission will go a little bit further and say, well, are we actually working in accordance with those terms? Is the contract really still being implemented, and is it still reflecting independent contracting agreement, which might be a little bit different from the approach taken if we were outside the Fair Work Commission system. But the key factors they're looking at are what we used to call the indicia, or the multifactorial test, and the indicia related to either employees and independent contractors. Now, the key sort of indicia I've listed here in a table, I'll go through them. The first one is control. And you'll see control really was one of the crucial things that the full bench considered in the Pasquale decision that I'm going to talk to you about at the end. An employee has very little discretion over how they perform the work and the tasks they are required to perform. They're directed to do things by an employer, and that direction is sort of binding upon them. Where an independent contractor who's operating their own business can exercise a high degree of control over how they perform their work tasks and when and how they are performed. So here we have a situation where we may have very specific things we want a contractor to do, but if we're essentially saying, we'll tell you as you go, that's not going to necessarily be viewed as a good indicia of it being an independent contracting arrangement. Where if we're specifying we want certain outcomes, and there are parameters around those outcomes, but they still retain some discretion as to how the work's performed, that may well be somebody who's running their own business. And if we think about it, that's what we do with our accountants. If we engage an accountant to do work for us, we don't necessarily tell them how they're going to do the work, even though we have predetermined outcomes that we want them to complete, like please help me complete my tax return. Different accountants have slightly different processes, but we don't dictate to them how that work is performed. How the work is undertaken, an employee only works for one employer, where an independent contractor has a right to undertake work for multiple or different businesses. Now, that can be quite a challenge, particularly where we're perhaps providing confidential information to an independent contractor, or that independent contractor has us pretty much as their major client. But the issue here is that what's important is that an independent contractor should at least have some sort of right to delegate the work, even if the right's not completely unfettered. So the situation might be is that they designate a specific person, but they have a right to delegate it with the approval of a suitable person being proposed. By doing that, you're saying, yes, you still retain the right to delegate the work, but it's not, you just can't go and delegate it whenever and whoever you want to. It needs to be something that's discussed with us, and we won't unreasonably deny that from occurring. But at the same time, it may be that, they're going to have to show you that they're a suitable person or a suitable designated person to perform that work before you give such approval. That independent contractor still has then a right to delegate, which an employee never does. Like, as an employee, you can't go and say, look, I'm not coming to work today, but I've sent in my mate who, he can do it, obviously. But if you have a clear situation where you say there's no right of delegation, that's going to be viewed more as an indicia of an employment relationship rather than an independent contracting relationship. An employment relationship also has a minimum or set number of hours, where an independent contractor is usually free to set their own hours provided the tasks are completed. Now, if we're talking about an overseas contractor, it may well be suitable that we say that we want them to be available to be able to be accessed during Australian business hours. That's not necessarily an unreasonable task, because, we're not necessarily going to call an independent contractor in Spain at 2 a.m. to talk about how the services are going or seeking clarification about those services. But if we're specifying that their hours are 7.6 a day with a lunch break, a meal break, and that they need to clock in and clock out or be on a particular system, that's not necessarily going to reflect a true contracting arrangement. So how that agreement, again, or how the hours are specified in the independent contractors agreement is going to be very, very important. Employees have the right to paid annual and personal leave, where an independent contractor does not. Now, if we're essentially saying to an independent contracting agreement that, oh, by the way, we're going to offer you the ability to take annual leave, or that you need to call in and we will pay you a certain amount of sick leave, again, that's not going to really be convincing to the court or a commission that this is a true contracting arrangement. Tax arrangements we're all sort of familiar with. An employee gets PAYG withheld, and an independent contractor is fulfilling their own tax obligations in the country in which they are based. Tools and equipment is a pretty interesting one. An employee usually uses equipment supplied by the employer, where an independent contractor usually provides their own tools and equipment. And for overseas contractors, this often is an area that becomes a point of contention, because quite often Australian principals will want them to use, say, a laptop that's linked through a secure system for an overseas contractor to undertake their work. In that situation, you need to quite clearly specify why that is the case. And you may also want to say, okay, we're supplying you this equipment, but it's a little unusual, but we're hiring it to you, or that this equipment is provided and there's a reason we're requiring you to use this equipment. But if we're simply providing all the tools of trade and we make no mention in the independent contractors agreement, the provision of such tools and equipment, or computer equipment, or access to networks, those sorts of things, may well work against an Australian-based principal, and they may well end up being deemed the employer rather than a contractor. And it needs to be carefully worded in that independent contractors agreement if that's the case, and it is often the case. That we're requiring this information or this system to be used, and quite often it's to meet the the confidentiality or the privacy requirements of the nature of the work that people are performing as well. Uniforms, it's probably more applicable to situations for Australian-based contractors, but employees usually wear a uniform provided by their employer, where an independent contractor doesn't usually wear a uniform. And if they do, it's usually the uniform associated with their own business. But it goes as far too then is that if we provide them with email and their signature block is reflecting that they're working as an employee of the business, again, we're holding that contractor out as being an integrated part of our business. So quite often there, you may well need to specify, even if they're using, say, a signature block, that they are performing work as a contractor rather than as an independent, rather than them just being an employee of part of the business. So you can see there that the contract that we draft really needs to take into account some specific circumstances, and where there are things that are a little bit unusual or don't really reflect that independent contracting arrangement, we would need to be able to provide some explanation or justification as to why that's the case, or also point out in many regards, why they are operating their own business. The risk of having a poorly drafted independent contracting arrangement means that you will be at risk of a sham contracting application being made. And sham contracting happens when a business presents a worker as an independent contractor when in reality they are actually an employee. And if the misclassification is deemed to be intentional to avoid their obligations such as minimum wages or leave entitlements, superannuation, or to deny them the ability to access workplace rights like general protections or unfair dismissal claims, we can end up with a situation where the employer is deemed to be in breach of the sham contracting provisions under the Fair Work Act. Now, the key to this is that sham contracting is usually intentional, okay, or that it's a false statement that's being made. You're not necessarily going to be hauled before the courts or the commission under a sham contracting contravention if you've done it inadvertently. But even if you have done it inadvertently and the contract is deemed to be an employment contract rather than an independent contracting arrangement, you're still going to be subjected to a range of unexpected penalties, I suppose, in a sense of that you may well be held liable for underpayment of wages. You may well be asked to go back a substantial period of time to pay, update their superannuation or to remedy the taxation shortfalls. On top of that, there may well be penalties for breach of modern award requirements, and there also could be a range of other legal actions brought against you, namely unfair dismissal or general protection claims. So it is a significant risk that may well be able to be avoided if we have a properly drafted contract that reflects the true nature of the arrangement at the outset. Again, identifying sham contracting. The key criteria that we sort of went through on those indicia are again the same sort of criteria that the courts and the commissions are going to look at. They're going to look at whether the worker is performing work under the direction control of the employer, whether the worker is, if they're a worker, they're not financially responsible for making a profit or a loss, where if they're an independent contractor, they're running their own business and responsible for their own financial outcomes. So there's a risk with an independent contractor that they possibly could make a loss, particularly if they were required to rectify deficiencies in their work, or if they've underquoted to perform the services that they've agreed to provide, where an employee doesn't bear such a financial risk. An employment contract, again, an employer tends to provide the necessary tools and equipment, and they can't delegate and subcontract their work, and they work set hours. All the things I spoke about are all. So if you've got all those things in there and you haven't really got any explanation as to why those requirements are in there, again, it may well find that you are at risk of a sham contracting arrangement, where if you update your contracts, and not all independent contracts are going to fulfill all of the indicia, but where there is an indicia that's perhaps a bit unfavourable, having an explanation or an amendment to explain what that requirement is or why that requirement is in place within the agreement will go a long way to minimising the risk of a sham contracting arrangement. I'll just move forward. I want to get to the recent case law. So this is one of the keys that I want to understand where this is all coming to a bit of a crunch. And I think a lot of you may well be surprised of the background to this story, and then also what the outcome of this decision is. So it's recent case law, and it's two cases. It's at first instance and again on appeal to the full bench of the Fair Work Commission. But the situation is that Joanna Pasquia is a Filipino national, and she lives in the Philippines, and she was engaged by the Docel Group, which was a law firm, a company based in Australia, as an independent contractor to perform paralegal functions remotely from her home. What she was actually doing is that she was working for, we've probably all heard of it, you see them advertised at times as a credit repair company called MyCRA, and she was working as a bit of a paralegal investigator to help people try and overturn credit defaults, etc., on their credit records. Upon termination of her employment and termination of her independent contractor agreement, and it was a little bit of a tense termination too. So Miss Pasquia didn't have a very good relationship with the principal of that law firm, of the Docel Group, Mr. Docel. And as a result of that, she was terminated for an alleged breach of downloading commercial information away from a company supplied work computer to another source. She denied doing it, but they instantaneously terminated a contract. But after they terminated a contract, Ms. Pasquia filed an unfair dismissal claim against the company. Now, the outcome of this, and I go through some of the findings issued by the Commission, but the outcome was that, and at both instances, so a commissioner sitting alone and the full bench both determined that Ms. Pasquia was not in fact an independent contractor, but in fact was actually an employee of the company. And as a result of that, Ms. Pasquia was found to be covered by the National Employment Standards and the Fair Work Act, and thereby she was granted standing to pursue an unfair dismissal claim against the Docel Group. Now, the cases don't determine the outcome of that ultimate application. It just determined her standing. But if she was an independent contractor, she would have been excluded from being able to bring such a claim. If she was an independent contractor and she was deemed to be an Australian-based employee, she would be able to bring such a claim. Now, the matter may well have gone to conciliation. I don't know. It may well have resolved through a settlement. But the interesting fact here is that a Philippines-based worker who had a written independent contractors agreement was able to bring a claim and be viewed as an Australian-based employee due to the nature of the written agreement that she had and the way she performed her work. So why was Miss Pasquia found to be an employee? And it's interesting here, and this was approved, the approach was undertaken at first instance, but the approach was also approved by the full bench. And what they said is that the Fair Work Commission considers the terms of the contract and the obligations of the parties, and they summarise the proper approach as follows. The assessment of the legal nature of the relationship between the parties is to be determined by evaluating the nature of the contractual obligations of the parties arising from their contract. What is required is an evaluative judgment of that contract, which will be informed by various indicia, some of which may suggest an employment relationship and others a relationship of independent contractor. So again, they're quite clearly going to the multifactorial test and assessing the terms of the written agreement against that test. Now, the key aspect at first instance is found at paragraph 29 and paragraph 30 of the decision of the first decision. It says, how was the contractual relationship established by, and how was the contractor agreement analysed? And you can see here it says, in short, at least where the rights and duties of a party are comprehensively committed to a written contract, and the validity of such contract is not challenged on the basis that it is a sham, and the terms of which have not been varied, waived, or the subject of an estoppel, the rights and obligations established by the contract are determinative as to the legal character of the relationship. So where we've issued a contract and we're working in accordance with the terms of the contract, the written terms of that independent contracting arrangement will determine the relationship. Now, it's not enough, though, just to simply say in an independent contractor agreement that I'm an independent contractor. The indicia or the terms of the agreement must also reflect the true indicia of an independent contracting arrangement. The characterisation of the relationship does not require or involve a wide-ranging review of the entire histories of the parties' dealings, except to the extent that there is a contention that the contract was varied or a waiver has arisen and the subsequent conduct of the parties does not reflect the true nature of the legal nature of the relationship at first instance. So if we moved a long way away from how the independent contractor's arrangement or the terms of how the work was performed or the requirements of the terms of the initial agreement, they're not necessarily going to be stuck with those terms. But if the nature of the work is reflecting, what we've agreed, then essentially contract still will be of great significance. But again, a simple label will not be enough. The agreement has to reflect and have to still be deemed, using that multifactorial test and those indicia that we earlier spoke about, it still has to reflect a true contracting arrangement. Then once the terms of the contract have been ascertained or determined, it is necessary then to characterise the relationship created by the contract, i.e., is it a true contracting arrangement or is it one of employment? Now, in this instance, the Commission held that Ms. Pasquale was not an independent contractor, but rather an employee, and it was based on the following factors. The contract stipulated that Ms. Pasquale was the sole individual authorised to perform the service and work could not, in any circumstance, be delegated. Secondly, the Commissioner found the role of a paralegal did not fall within the scope of a profession, trade or distinct calling typically associated with independent contractors. They said essentially she was performing an administrative service, right? There was nothing special about the service that they were requiring her to do. Essentially, they're saying she was a clerk. Thirdly, and this one's perhaps a little bit more challengeable, and the Fair Work Bench noted that it may not necessarily be determinative, but they didn't express a final view either way. Ms. Pasquale was compensated at a rate below Australian minimum wage, which again, in the Commissioner at first instance's opinion, reflected that she wasn't doing anything special that would reflect the true nature of an independent contractor. What is missing here a little bit, in my view, is that they didn't consider the fact that the rate that Ms. Pasquale would have been receiving was actually quite a good rate of pay in the Philippines. But I suppose it's a matter, and it's an issue, though, that's going to be determined on another day. But essentially what the Commissioner at first instance was saying is that he would have expected that a contractor, no matter where they're based, would be paid more for a specific skill or service than an employee under an award in Australia. Finally, she took instruction regarding the work to be performed and was subject to supervision in carrying out her duties. And in this regard, the supervision was constant and ongoing. There were constant chats, constant directions between Mr. Dossel and Ms. Pasquale. There was constant review of her work on a daily, if not hourly basis, that the Commission found was more indicative of an employment relationship than that of an independent contractor. And the arrangement was ongoing. There was no set end date unless it was terminated by either party. So it wasn't set, it didn't terminate at the end of a particular service. It was ongoing until one of the parties terminated the agreement, which is very, well, that reflects an employment relationship. Finally, some simple drafting errors also caused them a great deal of problems. The contract referred to the relationship in several places as that being of employment, reinforcing the nature of the arrangement. And that's where hybrid contracts or contracts where people have drafted and haven't considered the fact of how important this initial agreement will be can just basically come back and bite you on the bum. So what the Fair Work Commission did is once they established that she, in their view, was working under an employment contract rather than an independent contractors agreement, they went to the next limb of the test to determine whether she could bring an unfair dismissal claim, and that was Ms. Pasquale an Australian-based employee? Now remember that she was engaged, lived in the Philippines, and worked in the Philippines. Yeah. But the test for an Australian-based employee is a bit broader than you would think. You would think someone in Australia, right? But it's a lot broader than that, and it's found in Section 35 of the Fair Work Act. And Section 35(2) says that an Australian-based employee is a three-limb test. It's a person whose primary place of work is in Australia, or who is employed by an Australian employer, whether the employee is located in Australia or elsewhere, or is prescribed by the regulations. It's B, which is the one that provides the expansive definition of an Australian-based employee. A person who is employed by an Australian employer, whether or not the employee is located in Australia or elsewhere. However, paragraph 2B does not apply to an employee who is engaged outside Australia and the external territories to perform duties outside Australia and the external territories. So some of the arguments that were raised in the Pasquale case by the employer were, well, I engaged her to work in the Philippines and she performed the work in the Philippines and her duties were performed in the Philippines. And those duties weren't necessarily performed for work performed in Australia or for an Australian-based employer within Australia. And the court looked at that closely, but they didn't agree with the employer's submissions on that. And what they actually determined, and they went through this in fine-tooth comb, what they actually sort of determined is that the contract was actually formed in Australia. And the reason for that is that the offer of acceptance was made to Ms. Pasquale, and then she accepted it. And by accepting it, she sent an email back accepting the agreement, and that receipt of that email occurred in Australia, which means that the contract, in their view, was formed in Australia. So you'll see here is that the first one is that the exclusion in Section 35(3) has two requirements that need to be satisfied to say they're not an Australian-based employee. And the first one has to be shown that they were engaged outside Australia. And the second is that they're performing duties outside of Australia. As I've already sort of said to you there, is that in their particular case, they viewed quite clearly that the acceptance or the formation of the contract was formed in Australia, and therefore that limb of Section 35 was not, Section 35(3) was not satisfied, and she could be viewed as an Australian-based employee. So what we have here is a situation where a business misclassified a virtual assistant as a contractor. The Fair Work Commission then viewed that they were actually an employee, and the business is at risk of having to pay back pay, super, and penalties if Ms. Pasquale brings those claims. And the issue here is that this perhaps could have been strongly avoided if we looked at correctly classifying and documenting the relationship in the independent contractors agreement to show that Ms. Pasquale actually was operating her own business. We could also perhaps have addressed a little bit more clearly that she did have a right to delegate, but the delegation of that work perhaps should have been not necessarily an unfettered right, but still she retained some right if she wanted to do that. We may also have looked at how we actually would have engaged her to provide those services. So rather than it being a situation where we were just setting, say, standard business, Australian business hours, we could have a situation where we were like specifying particularly what sort of outcomes we were seeking from her. And we could also say that's limited to a certain amount of hours, but not necessarily exercise the high degree of control that was exercised in the Pasquale case, which was almost immediate hourly supervision that was being provided. Again, also, the other aspect here too is that we engaged an individual, or I didn't, but in this case, the employer engaged an individual, okay? If you engage a company or a trust, they can never be deemed an employee because they're not a natural person. So one of the other aspects that needs to be taken on board is that if you're going to consider engaging an overseas contractor, you need to have a very careful look to say, A, do I hold a lot of the same risks that Darren's just spoken to me about today? And B, what steps could possibly be taken to mitigate that risk? And one of the first things that you could look at is to say, well, do I need to engage this person as a natural person, or would it be better to engage them through a corporate entity, which quite clearly demonstrates that they're operating their own business and are taking the risks associated with that? And then that business engages designated people to perform those services, but then they're the employee of that business, not of the principal. On top of that too, how the services are specifically prescribed, how the invoicing occurs, a range of different factors. If we're going to provide equipment, are we hiring that equipment to the person or to the entity? Are we providing a quite clear specification as to why they're using that equipment and what the reason for that equipment is provided? And certainly we'd be looking to avoid situations where we're paying them entitlements, etc., such as annual leave or long service leave, etc. But a full review, I suppose, is warranted given that the courts now are placing such extreme scrutiny on overseas contractors, and they're not necessarily limiting their abilities to access the Fair Work system in Australia from overseas. The other aspect you could look at is how are we remunerating these people? If you're paying an hourly rate and that hourly rate is perhaps lower than the modern award rates, you are probably going to expose yourself to unnecessary criticism and have to try and defend the claim. You may well be better off having the remuneration or the monies payable under the independent contract to not be linked necessarily to hourly rates. It could be linked for the perform of certain services, or it could be capped at a certain amount, or it could be outcome based rather than hourly rate based. All of those types of remuneration structures may well be very different from a situation where you're engaging somebody in a similar manner to what is required to be paid to Australian employees under modern awards. And the other aspect too is clearly specifying what the services are that we're engaging them for and why these are specific skills. Remember in the Pasquale case, they said there's nothing special about what she's providing, but quite often there is perhaps a special aspect of the services that they're providing. It may well be that she's, instead of paying an hourly rate and just saying, providing a similar sort of requirement of the services to reflect a position description, it could be linked to the specific services or outcomes that we're looking to provide rather than the tasks that they're being asked to perform. And I think, again, a careful look at the way we draft the independent contractors agreement before we engage those sorts of contractors would have gone a long way to removing the risks of what occurred in these two particular cases. So questions and answers. Sorry, I've covered a lot of ground today, but I think it is an important sort of area that we're looking at. I'll just pull up my my Q&A or my chat and see if there's any questions there. I've got one here from Emily. If you had a couple of employees based in the Philippines and they had their own virtual assistant businesses, so you could then offboard them as employees, engage them as contractors for the same administrative type work, would you see that any problem that could arise from that? Yeah, I can, Emily. The issue there is that you still have an independent contracting agreement that you drafted with the employees at the moment, and they would look at the terms of that independent contracting agreement. If they had their own business, I probably would terminate the original contract and enter into a new contract with that business through that corporate entity if they had that. And then, yeah, sure, you could put some restrictions on delegation, but they would then be free to do that. And that would be sensible. But again, you don't want to have that contract drafted in such a manner where, you know, and I suppose I'll point out here, you've said you had a couple of employees based in the Philippines. That's the sort of situation we want to move away from. We don't want them to be viewed as employees. We want them to be viewed as working under an independent contracting arrangement. So in my view, we would be far more sensible to look at what are the specific outcomes and what are we requiring in relation to invoicing and billing. Those sorts of factors that I've gone through would still need to be put in place, but you'd certainly have a lot less risk if we were then contracting with, say, a corporate entity who had a right then to delegate the work out with your approval. You would minimise your risk. But again, remember the court didn't say the labelling is the only thing that's important. Actually, what the indicia contained within that agreement was closely scrutinised. And, you know, in this case, they engaged an independent contractor and they were still deemed to be an employee. So yes and no, I think it would still require a full review to try and mitigate the risks. I'll pop to the chat as well, see if anything's popped up there as yet. So I think the key is we've drafted quite a few since, and I'm sure a lot of you weren't even sort of aware that this dramatic change had occurred, but you can see it's not just a decision at first instance. You'll see in the Pasquale decision, and I will take you to, at first instance, probably the key requirements sort of kick in about paragraph 25 and flow through to paragraph 32. But the full bench's decision, if you haven't got a lot of time, I'd suggest just downloading the full bench decision. And if you start right at the end, the overall assessment, and it's only a page and a half, it goes from paragraph 47 through to 50, you will see that they're very clear on what they're requiring employers to have for independent contracting agreements. And it's not just overseas employees, it's also the approach they're going to take to Australian employees. But I think the expansion of the Australian employees to overseas contractors is probably something that's coming as a little bit of a shock to most employers, because we thought, well, if I'm dealing with someone with the Philippines, that's not going to affect me here in Australia. It likely is, I suppose, is what it's saying. Mal's just putting it into here to me with as well. If we make a contract with a company overseas, will that one make it all good? It would be far more likely to be viewed as an independent contracting agreement if we contracted with a corporate entity, because it's very difficult, you know, for the commission to turn around and say an unnatural person is an employee. That person, sorry, that corporation tends to engage their own employees. But the only situation I would hesitate to say that it's 100% a curable, Navdeep, is that if they still viewed that contract was a sham. So again, you still want to have a situation where the independent contracting agreement with the company is more likely to be viewed as a true contracting arrangement than it being drafted that you've got an employment contract with a company, and that really is just a sham to to avoid, and the true relationship is with their with their employees, and we've just entered into that contract as a sham. So you still want your independent contracting arrangement with that company to be viewed as a true contracting agreement, but it will put a lot of weight in place for that contract to stand up if it was with a corporate entity or with a trust. Okay. I think the key here is that every circumstance is going to be slightly different. Yeah. So what I'd suggest, if people are worried about this issue, and I think a lot of you will be, scan that code and we'll have a chat to you about your specific circumstances. There are things we can do. It can simply be a matter of, let's get that contract to reflect what the true nature of the agreement is. And if there's problems with the current contract, let's amend the contract. Let's reissue the contract and let's get you off onto the right foot, particularly given the fact that the courts and the commissions are far more willing now to take an expansive approach. So, that I suppose that issue of contract is king, it's still important, but the contract needs to reflect a true contracting arrangement. Okay, we can't just simply say, I labelled them, I'm good, I'm safe. It's not going to stack up moving forward. I'll jump back to Q&A. What would happen if you... what would happen if your individual contractor that had their own entity had pursued employment elsewhere and not formally ended the contract? Would you still have the same approach as abandonment of employment? No, I wouldn't. Because if I had an independent contracting arrangement, I would have a termination clause in there. The independent contractor may well be in breach of failing to provide the services, and I would move forward with the termination under the independent contracting arrangement that was in place, and that would likely be notification of termination. I wouldn't do an abandonment of employment process because you wouldn't want to say that they're an employee. But again, it would depend upon how your original contract is drafted. But ideally, an independent contracting arrangement has its own termination requirements, which is normally a written notice to a certain address, notification of a breach, or a termination for any reason with a certain time frame. So the approach would be a little bit different. But if you did embark upon an abandonment of employment process, essentially you're creating yourself a risk of it being deemed that you viewed them as an employee rather than as a true contractor. I'll jump down to Tony. If I have an independent contractor with an ABN under his own name and a contract with a duration to end and an hourly rate per service provide capped to a maximum figure, and they handle their own super, is this contract still subject for being considered an employment arrangement? Well, again, there's some of the indicia. Some of those are indicia of an independent contracting arrangement, like them being responsible for their own tax and super, perhaps that it has a fixed date and that the rate is capped per the service, but it is an hourly rate and it is capped to a maximum figure. But what you're missing there, Tony, is that they'll also look at how the work was performed, the amount of control, what was provided, and what special services were being provided, or was it just basic skills? So it's not definitive. It's not going to be a definitive answer on the three you gave me, but you could probably strengthen that by strengthening a lot of the other indicia to make sure that it's more consistent and more likely to be viewed as an independent contracting arrangement moving forward. Particularly the ones that concerns me a little bit is the hourly rate. Do we necessarily need to pay them as an hourly rate, or could we agree it as per task, or could it be as per week? Could there be a requirement to have them rectify faulty work? which certainly isn't a requirement for an independent for an employment arrangement. So again, a little bit it would be about, well, okay, I've got this arrangement. Everybody agrees at the moment we're a contractor, but how do I strengthen my contract so it actually looks, you know, it's more likely to be viewed like that going forward? Elizabeth, if you engage a contractor in the Philippines who operates through a registered corporate entity and you have an independent contracting agreement in place, but in practice the contractor works like an employee. The only risk, Elizabeth, really, I think you're in a fairly strong position from what you're saying there, that I've engaged them through a corporate entity. And but the issue there is that it could be viewed perhaps that we strayed a long way from that initial independent contracting arrangement, and it doesn't really reflect the true nature anymore. And that's where you could be at risk that they turn around and say, well, I really am an employee. I think the key there is, if we have sort of moved away from that, is to get it back or reissue a contract that gets it back in place to say, okay, we might be at risk, but how can we minimise that risk by redrafting the agreement to minimise the risk, to say, well, you know, we haven't strayed so far, or we've amended the agreement and again we're reflecting a contracting arrangement, even though there might be a few tweaks on what we initially agreed to where we are now. Does that sort of make sense? If we make a contract with a company overseas, will that one thing make it all good? No, not necessarily, Navdeep, because again, they might turn around and say, well, we exercised a great degree of control, or if we were paying the employee, the contractor or employee directly, we weren't paying it through the company, but it would go, there'd be less risk in that situation. But again, they're not going to necessarily completely obliterate situations that they think are a sham just simply because we engaged with a corporate entity. But if it's not a sham, you'll be in a much stronger position by using that sort of structure. But if, you know, they're only ever working for us, they've worked for us for an extended period and we're exercising all the control over them, etc., you may well find that they say it is a sham, and then all of a sudden we're up for a range of different payments and penalties. So again, you know, that even that agreement that we're going to make with the company overseas, we want to be very clear that it is a true contracting arrangement and that we don't have employment type characteristics in there. I know I've kept you, we're just hitting 1 o'clock now. What I will do, there's up on screen is a QR code. If you want to have a chat further about it, please scan the code. We already do, we've updated our independent contracting agreements to sort of reflect the impacts of Pasquale. We're also providing for our employees in these sorts of situations a letter of advice, so we can justify that we have considered these factors and what the outcomes are. And that's sort of a letter that we're writing for two purposes. One is to inform you, you know, here are the changes, here are the requirements. But also if somebody came and challenged it, we could say, well, I did seek advice about this and this is why we changed these certain things. And here are the factors that were done at that time. And that can be really important because, as I said to you, some of these disputes might not rear their head for 5 or 6 years. And remembering exactly what you did and why you made those changes can be hard to do. Where if you get a letter of advice, which is subject to legal professional privilege, it's sort of mapped out there why we've made these changes and that we considered these changes and why it's a true contracting agreement. So we're writing it with a view to the future that you'll need to rely upon that letter of advice at a later time. And we've strengthened the agreements that we tend to issue to take into account that we're putting you in your best possible position, that the Fair Work Commission is going to view that as a true contracting arrangement rather than an employment relationship. So that's probably the key factor that I'd say take into account is let's get your situations where, you know, if you've got doubt, let's address it now rather than waiting for a problem later on. So thank you very much for attending. I appreciate all of your time and hopefully that was of some benefit to everyone.